The Supreme Court will now consider whether a state can put in place a Second Amendment Preservation Act with the purpose of making the state a two-way sanctuary state. But now the Trump administration in power is asking for more time to consider how they want to handle this case and this lawsuit. Now, before we jump into this video, I want to thank the sponsor of this video, which is AOR. When it comes to self-defense protection, don't settle for insurance limitations. AOR is a real law firm, it has real attorneys, and it's not dependent on an insurance company. Although I may not agree with all of what Mark Victor says and all of his ideologies, there is no doubt that AOR and its program is the best on the market. With AOR, you get direct access to an attorney 24/7, plus they cover cases others won't, like self-defense situations involving illegal weapons, gun-free zones, and even incidents involving alcohol. So if you're interested in protecting yourself and checking out AOR, I will leave a link to them down below in the details section and the pinned comment. And if you sign up and use the code ARMEDSCHOLAR, you can get $50 off your individual sign up or $25 off of your family plan. So check out AOR using those links down below. So like I said in the intro, in this video, we're going to be talking about a huge Second Amendment case that is once again back in front of the Supreme Court. This case is dealing with a state's Second Amendment Preservation Act, and we've discussed this case before because recently the Supreme Court issued an order denying a stay that would have protected the state of Missouri's Second Amendment Preservation Act, also known as SAPA. But now Missouri has filed for official Supreme Court review. They filed their petition to the Supreme Court, and the Supreme Court will now consider whether or not they want to grant review to this SAPA issue. But now something else has changed in this challenge. The Trump administration is back in control, and they recently asked for additional time to file their reply brief to the Supreme Court because they want to review this case. They want to see how they want to handle this issue going forward. And also remember that there's now in play the executive order by Trump, which is aimed towards protecting the Second Amendment. So they are reviewing a lot of these cases and a lot of these issues that the Biden administration took up and litigated heavily. And now the Trump administration wants to see what they want to do with this Missouri SAPA issue. Now, for those not familiar, back in 2021, Missouri passed a law called the Second Amendment Preservation Act, known as SAPA. That law set the state's interpretation of the Second Amendment and set restrictions on the support and funding that the state would provide to federal agencies in their attempts to enforce federal laws that violated the Second Amendment. The law prohibits Missouri's officers, agents, and government officials from helping federal agents who are attempting to enforce inconsistent laws or federal laws which Missouri believes are violating the Second Amendment. Now, this law also created a civil remedy where anyone could sue Missouri officials if those officials help to enforce federal laws in violation of the Second Amendment. The Missouri law is similar in nature to the Texas abortion law, SB 8, and the recent Supreme Court decision in the whole women's health case. With the Texas and Missouri law structures, you can't get an umbrella injunction against the state or the attorney general or any of its officers or agents because they're not the ones actually enforcing the law. Instead, you would have to get an injunction against individual residents who are filing these civil cases. Now, in this Missouri case, the District Court on review ruled in favor of the Biden administration, striking down the Missouri SAPA law in its entirety. Now, in response to that, the state of Missouri then appealed up to the 8th Circuit. Missouri also asked for the 8th Circuit to stay the lower court decision while the appeal was taking place. However, the 8th Circuit denied that stay request. That then led Missouri and the AG there to file emergency applications to the Supreme Court, and they wanted the Supreme Court to grant the stay on that lower court decision. But on review, the Supreme Court issued an 8-1 decision denying that emergency request for a stay. Only Justice Thomas was in favor of actually granting that stay in the favor of the state of Missouri. After the Supreme Court denial of that case, the case was then sent back down to the 8th Circuit, who then held expedited arguments in this case, and then they issued their decision. And ultimately, they ruled in favor of the Biden administration, striking down the SAPA law in its entirety. But in response to that new decision, Missouri has filed a writ of cert to the Supreme Court, and the petition is now on the final merits and it's in front of the Supreme Court. Now, in this petition, Missouri presents 3 main questions for the Supreme Court to answer and consider in this case. First, can federal courts second guess a state's reason for exercising 10th Amendment authority? Second, does the Constitution prohibit states from exercising 10th Amendment authority when motivated by a concern that a federal statute is unconstitutional? And third, is a state official a proper defendant under Ex parte Young simply because the official is regulated by a statute, or does the official also need to possess authority to enforce that law? Missouri goes on to argue in the petition that before this case, it appears no federal court had ever blocked a state from exercising 10th Amendment authority simply because of the reason the state expressed for exercising that authority. The 8th Circuit did that here, striking down a state law solely because the act said that the legislator believes certain federal statutes are unconstitutional. The 8th Circuit's holding creates multiple circuit splits and is as wrong as it is unprecedented. It declared a Missouri law unconstitutional solely because of the law's legislative findings, specifically the legislator's opinion that some federal statutes are unconstitutional. The court took no issue with what Missouri's law does, only with what the legislative finding says. Indeed, the court agreed that a law with the same effect but different findings would be permissible. Now, one of the things that Missouri is pointing out here in the petition to the Supreme Court is that the 8th Circuit essentially said that the structure of this law and the potential operation of it is in fact valid, but ultimately the 8th Circuit struck it down because the underlying Second Amendment purpose of this is something that the 8th Circuit did not like. Missouri also argues that the 8th Circuit went against clear precedent and essentially found that state officials could be sued because the 8th Circuit believed that the state officials played some sort of a role in enforcing this law here, even though the officials here actually aren't doing anything. They're just not doing something, but here the court believed not doing something is actually doing something. Now, this law was opposed by the Biden administration, but now with the Trump administration in control, the government's position in this case may likely change. Originally, the federal government was set to file their reply brief to the Supreme Court on February 26th, but now the Trump administration has asked for an extension of time. In the recent motion to the Supreme Court, the Trump administration states that the petition for a writ of certiorari in the above captioned case was filed on January 23, 2025, and placed on the docket on January 27, 2025. The government's response is due on February 26, 2025. We respectfully request under Rule 30.4 of the rules of this court an extension of time to and including March 28, 2025, within which to file the government's response. This extension is requested to complete preparation of the government's response, which was delayed because of the heavy press of earlier assigned cases to the attorneys handling this matter. Also keep in mind, just days after the request for this extension, the Trump administration issued an executive order to protect Second Amendment rights. His office and the Attorney General are now kind of reviewing all the Biden policies and all the lawsuits that they engaged in from January 2021 to 2025. This is one of those significant cases that the Trump administration and the Attorney General will now be reviewing and essentially issuing a plan of how they want to handle these going forward. We've already seen his office request a pistol brace case to be put on hold, be put on abeyance, and I suspect that this Missouri case and others that we're seeing these extensions being requested is kind of the similar thing happening. The administration is identifying what cases they have kind of on their hands, what are they taking on because of the Biden administration, and they have to come up with a game plan about how they want to handle these, how do they want to litigate these, do they even want to litigate these going forward, or what their actual replies and responses are now going to be that they have control of these cases. My preference would be to resolve this case actually in the Supreme Court so that we get a pro to a precedent on the book. I would like to have something very resolute so that ensures future administrations cannot simply just change things, in the next 4 years when someone comes into office. Heaven forbid, another, Biden or someone like that comes into office again. We don't want to have to go through another kind of carousel of lawsuits like this. So I'd rather this actually be resolved in the Supreme Court and we get precedent on the books to prevent this type of stuff going forward. So we're going to keep our eyes on this to see what happens going forward and what the Trump administration wants to do with this case. And as we get more information, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube and tells the algorithm that you see value in this, that it should share it to more people, and this type of two-way information is relevant and helpful to others. But regardless, thank you guys so much for all of your support. Don't forget to like, comment, share, subscribe, and never forget this nation was built by ARMED scholars, and this nation will be maintained by ARMED scholars.